Good afternoon, everyone. Welcome to NITYA Monologue, GST on secondment of employees from foreign entities. As you may be aware that this secondment agreements are very much prevalent in multinational companies where they depute foreign employees to their Indian counterparts. And this has been a bone of contention both under direct and indirect tax laws for long. Till tribunal level, this issue has always been decided in favor of taxpayers that no service tax is payable on these secondment arrangements. But a couple of months back, we had Supreme Court ruling in case of Northern Operative, which said to the contrary. So the court held that it's an import of service and service tax is payable. We will be discussing in detail about the correctness of the judgment, but irrespective, this was mostly a revenue neutral exercise because whatever tax would have been paid by the taxpayers would have been available as ITC, and there were large interest, penalty, ITC implications. So a lot of representations happened before GST Council, government, etc., by various industry bodies to clarify this issue. But in recent past few weeks, we noticed that many of our clients have got notices from DCGI seeking data information relating to these secondment arrangements, which indicates that this representation may not work for the time being, and the department wants to take this issue heads on with the taxpayers. So in this background, we thought that we'll conduct this legal monologue in which we'll discuss the Supreme Court ruling in detail and what's our take on various implications which will arise out of this ruling. So in today's webinar, we'll be discussing background of the issue, statutory provisions, including from employment laws perspective, Supreme Court ruling, recent inquiries by DCGI as to the qualitative information which DCGI is seeking, our take on the issue, and we'll end the webinar with live Q&A where we'll give you an opportunity to ask questions live. Yeah. So starting with the background, in a typical employee secondment arrangements, foreign entities are present all over the globe. They have expertise, they have people who have diverse, varied experience. So they send their people on secondment to Indian entity. And how does this work is that the purpose is that Indian entities may need support or expertise in running of the business in India. They want these foreign employees or seconded employees to hold key positions as head of departments, as directors, CEOs as well. Importantly, these seconded employees can be paid in any of the following ways. So even amongst our clients, we saw divergent or diverse practices. In some cases, seconded employees paid fully by the Indian entity. In some cases, seconded employees paid fully by foreign entity, and they do not seek and they seek a reimbursement from the Indian entity. And in many of the cases, it's partly also that whatever expenses seconded employees are incurring in India, to meet that, the Indian entity pays to them, and remaining Indian entity remits to foreign entity, who in turn puts into the bank account of the seconded employee. So all these three type of arrangements are in vogue. Indian entities also provide various perquisites to seconded employees in terms of their residence, vehicles, etc. Now, from a documentation perspective, generally we saw secondment agreement entered into between the foreign entity and Indian entity. There's an employment letter which is issued to the employee. There is an employment visa under which employee comes to India, and there is a FRRO registration, which is Foreign Regional Registration Office. So in that case, in these cases, a certificate is taken from FRRO as well. From a compliance perspective, in most of the cases, Indian entities do compliance under employment laws, which is like PF, etc. And whatever amount is being paid to employee as salary, irrespective of manner of remittance. And in most of the cases, we all saw, because their period of stay will be significant in India, so even their global incomes are included and income tax is paid on that. Now, coming to statutory provisions. So under service tax law till June 2012, means prior to negative list regime, the tax was on manpower recruitment or supply agency. Law defined this agency as a person engaged in supply of manpower. In that context, the taxable service definition covered supply of manpower services by a manpower recruitment or supply agency. When the negative list regime introduced, so every service was taxable except what was there in the negative list. So in our context, the negative exclusion was services provided by employee to employer. Under GST law as well, Schedule 3 lists out activities which do not qualify as supply. So services by employee to employer are outside the purview of GST. So if we'll see, as far as indirect tax laws are concerned, be it service tax or GST, employer-employee transactions are always outside the purview of indirect taxes. In fact, very recently, CBIC issued a circular as well that whatever employer is giving to employee as part of contractual obligation, which can be various perquisites or anything, that's always outside the purview of GST. Now, the important question comes up in the present context is that who is an employee? In which situation it will be treated as an employer-employee relationship. So when we look at meaning of employee under various dictionaries, like Merriam-Webster's dictionary defines a person employed by another, usually for wages or salary. Similarly, Collins Dictionary define employee as a person who is paid to work for an organization or for another person. Now, if we take various statutes, so like Factories Act defines worker as a person employed, whether for remuneration or not, in any manufacturing process or incidental or connected to manufacturing process. ESI Act also defines employee in a similar way as person employed for wages or in connection with work of factory or establishment. And same way, EPF Act also defines it as a person employed for wages in any kind of work or in connection with work of an establishment and get wages from employer. So the purpose of putting these dictionary meanings of employee or various statutory meanings of employee was that when the whole dispute is who is an employee, and in particular GST law or service tax law never defined who is an employee, we can take resort to dictionary meanings and various other statutory definitions. One common thread which flows from all these meanings and statutes is that the definition of employee is generally very wide. Person who is employed for wages or salary. So if a person qualifies this criteria, he will be considered as employee. And as far as these statutes are concerned, they don't have any particular exclusion or exception to this general category. So the main question we'll be discussing in next few minutes is that when a foreign entity seconds employee to an Indian entity, whether he will be considered as employee for the purpose of GST law or not. So as a run-up to this webinar, we conducted 2 polls, and subsequently in our session, we'll be giving our take on these questions also. So the first poll question we ran was, if a taxpayer today pays GST under RCM for past period on employee secondment arrangements, can it claim ITC? So 85% of the participants felt that ITC is available. The second question which we discussed was, will the Supreme Court ruling in case of Northern Operating Systems have adverse implications in the income tax laws? So again, majority of people, 74%, felt it will have implications. So we'll be discussing in next few minutes. Now, dissecting the Supreme Court decision. So first, what were the facts? And understanding the facts of the Supreme Court ruling is very important. And maybe in the end, it will help to come to a conclusion that in which set of facts the Supreme Court ruling will apply. Will this have a generic implication, or it will have a very specific implication? So in this case, employees were seconded for providing backend support services. So Indian entity was providing backend support services to overseas entities, and employees were seconded for that purposes. Indian entity was employed for all purposes, so all employment compliances, all income tax compliances, everything was undertaken by Indian entity. The only role of foreign entity which was left was that whatever social security and retirement benefits of seconded employees were there, those were borne by the foreign entity. And very specifically, very importantly, that other employment terms and conditions of seconded employees with foreign entity ceased. Foreign entity's role was only restricted that it made seconded employees available to the Indian entity. So, in these set of facts, what factors were considered by Supreme Court? So, Supreme Court said that substance of the agreement determines nature of transaction. So, substance over form principle was applied. The Supreme Court take cognizance of multiple agreements which the taxpayer was having in that case, like a service agreement, secondment agreement, etc. Supreme Court also laid emphasis that the employees were seconded for a specific duration and for undertaking specific tasks. Court noted that the employees possessed specialized skills, not generic ones. Salaries of seconded employees were fixed in dollars, not INR. They were paid a hardship allowance in India. And the foreign entity continued its employment because, and Supreme Court came to this conclusion based on the fact that social security benefits were continued to be borne by the foreign entity. So, on this basis, the Supreme Court concluded that, in essence, this is not a employer-employee arrangement, and this qualifies as import of service by Indian entity. So now we will give our take as to, out of all these 7 factors, which factors were rightly considered by the Supreme Court, and with due respect, which factors were not relevant but still laid emphasis by the court. So substance over form is absolutely correct point noted by Supreme Court. Even multiplicity of agreements and specific duration of task was also a very unique fact in that case, which indicated that these seconded employees were sent for performing a specific task for the foreign entities. So it was a circular arrangement that foreign entities send seconded employees to India. Indian entity uses those seconded employees in turn to provide services to the foreign entity. So that was a unique fact which the court considered, which may be relevant depending upon the facts. But observations like seconded employees possess specialized skills, in our view, may not be determinative, because even as an employee, I may hire a highly qualified software engineer, highly qualified lawyer, etc. in my company. So just based on one factor of specialized skills, it will be incorrect to conclude that employment does not exist. Even factors like salaries of seconded employees fixed in dollars and separate hardship allowance paid in India, in our view, may not be relevant, because nowadays we see, be it airlines or very large companies, auto companies, etc., they hire very independent CEOs from outside, not from the group companies. And if someone is coming from overseas, he may prefer for a forex parity or this thing, etc., that his compensation should be fixed in foreign exchange. He may be relocating from his usual home country, etc. So he may expect a hardship allowance also. So in our view, these are factors very much prevalent in the commercial world, not only with the group companies. So these also may not standalone lead to a conclusion that it's an import of service. Even continuation of employment with foreign entity for limited purpose of social security benefits, in our view, may not be a decisive factor, and this point we'll be discussing in subsequent slides. So the decision was that the court held that direction and control test is not sole criteria to determine whether Indian entity is an employer or not. Basis above factors, the court came to conclusion that foreign entity provided manpower supply services to Indian entity, and Indian entity should pay service tax under reverse charge. So because we are 5 years from service tax regime, etc., and limitation period for raising demands have expired, so this issue does not have any bearing for service tax issues unless a company has already facing litigation. But yes, this issue will be more relevant from a GST regime perspective. Very importantly, the court made an observation that it's a very fact specific case and do not have universal application. And in our view, this all participants can keep a note that every secondment arrangement will not necessarily fall under the purview of the Supreme Court ruling. A very important argument which the taxpayer took, which unfortunately was rejected by the Supreme Court, was on revenue neutrality. So, in this case, the taxpayer was in a taxable business, so he took an argument that even if it pays entire service tax, he would be entitled for SINVAT credit. So, this argument was also unfortunately rejected by Supreme Court, despite there were a number of earlier Supreme Court rulings which said in indirect taxes only if excise duty service tax paid is available as SINVAT credit, it's a revenue neutral exercise both for the government as well as the taxpayer. And in the past, the Supreme Court had quashed demands on that ground. But this argument did not find favor with Supreme Court here. Supreme Court held that extended period is not invocable because the case involved interpretation of facts. In the present context, it will be relevant because the criteria for invoking extended period and imposing penalty is identical. So there needs to be existence of mens rea, malafide, fraud, suppression, etc. So the court came to a conclusion that these factors were missing. So this will also come handy in future to resist demands of penalty. Now we'll highlight that some of the factors which unfortunately were not considered by Supreme Court. First, very important, employment compliances undertaken by Indian entity. As we discussed few minutes back, that definition of employee under various statutes, meaning of employee under various dictionaries is very wide. Secondly, when in this case, the taxpayer did all the compliances with PF, income tax, etc., and once those compliances were accepted by those statutory authorities, it meant that those seconded persons qualified as employees only. So, for a limited purpose of service tax, in our view, the Supreme Court incorrectly ignored all the employment compliances which the taxpayer undertook. Second, in our view, there is a concept of dual or joint employment, which is very much prevalent in industry, where I, as a person, can take employment in two companies simultaneously, as long as both the employers are aligned. So this is prevalent. This is nowhere barred also. So in our view, even if Supreme Court came to a conclusion that employment with foreign entity continued for the purpose of social security benefits, that does not change that he continued to be an employee of the Indian entity. So even this factor was ignored. Supreme Court ignored that seconded employees reported and responsible to Indian entity only. So they were working under control and direction of Indian entity. Indian entity had a right to accept seconded employees once deputed. So we can say that I don't want to take the seconded employees. They had a right to terminate those seconded employees if they were not working as per expectations. So, which indicated that in this case, employment existed in essence. And yes, the Supreme Court ignored the jurisprudence or statutory definitions which were there in the other laws. In the recent inquiries by DCGI, they are seeking information like annual audit reports since inception of GST, seconded agreements, letter of understanding or employment letter with seconded employees, what sort of payments, allowances have been given to seconded employees, and Form 3CB and transfer pricing study report. Now we'll come to the last and from our perspective most important section is to our take on the Supreme Court ruling. So in our view, all the companies who have secondment arrangement should undertake assessment of applicability of Supreme Court decision, if not yet undertaken, because this does not have a universal application. There were certain factors which were present in unique factors which were present in that case. There were certain things which are not considered by Supreme Court. So in our view, any and every secondment arrangement will not fall under the purview of Supreme Court ruling. This may not only have implications with transactions with foreign entities. So if you have group companies within India where domestic employees are sent on secondment, in that case also this will have implication. Third point which we want to highlight is that in a case where employees are seconded without any payment, what will happen? So say for example, I'm an Indian entity, my foreign counterpart, he sends few employees here, and as an Indian entity, I neither make any payment to the group companies, I don't make any payment to the employees. In our view, this issue may still be relevant. And why do we say that is that under GST law, we have a concept of deemed supply in which Schedule 1 says that even supply of goods or services without consideration are treated as supplies, and entry 2 specifically covers supply of services between related persons. Therefore, if any company has such arrangements which are not monetized, even those may fall under the purview of Supreme Court ruling. Now, moving ahead, that even if GST liability arises, companies should consider whether they should admit it or they should pay under protest. And why we are raising this point is that if the company feels that it is not squarely covered by Supreme Court ruling, some factors, etc., it has unique or which are distinguishable, etc. So in all those cases, it should consider making payment under protest so that future demands of interest, penalty, etc., those can be refuted. One very important point is the valuation. So say for example, I'm an Indian entity who has got employees on secondment for which I make reimbursement of say 1 crore to the foreign entity. So ordinarily 1 crore I have paid, so that should be the value. But in our view here, there is something which we can play around in our favor. So under valuation provisions under GST, Rule 28 deals with value supply between related parties. And generally, open market value should be taken. But the second proviso says that where recipient is entitled for full ITC, value declared in invoice will be deemed to be OMP. So how this proviso is relevant for us is that in my example, if employees have come on secondment from a foreign entity. So in those cases, there'll be a reverse charge liability which will arise if applicable. And then I, as a recipient, will be liable to pay GST. Since most of the companies, most of the participants, most of our clients, they are in a taxable business where anything and everything which is paid is eligible for ITC. In that case, whatever value I declare in invoice, here invoice will be a self invoice which I'll be raising for RCM, will be deemed to be OMP. So legally, in our view, even if for secondment we are paying 1 crore to the overseas entity, we can raise an invoice of rupees 100 for a year, and that will be sufficient discharge of liability. Um, in our view, this is not only being supported by very clear legal provisions, there are multiple advance rulings, even though GST advance rulings are mostly against taxpayers, but at least on this point, there are multiple advance rulings, like in a cross charge situation, in a stock transfer situation. So the advance ruling authority has read this proviso that you can adopt any value. So, in our view, why this will be relevant and companies should consider doing this compliance is that if, say, 1 crore related to 1718 and we are paying 18 lakh GST now, so the interest liability will also become automatic. Whereas if we reduce the value, so interest will also correspondingly reduce. And in our view, that may be a sufficient compliance under GST law. Then ITC availability for past period, in our view, there are two factors which we need to consider. And after that, we'll come to our take on this, that if GST is paid for the past period, ITC is available or not. One issue which merits examination is limitation, whether the claim will become time barred or not. So section 16.4, which prescribes timeline from claiming ITC, which yesterday night was increased to 30th November. It links time limit for claiming ITC with the date of invoice. So when the invoice is being raised, it is not related to date on which or the period to which those invoices pertain. So legally, if say in the month of September 22, we raise a self invoice for the past, say 1718, because the invoice date is a current date, so this time barring provisions will not apply. Second aspect which we should consider is that 17.5I specifically bars credit wherever tax is paid under section 74. So section 74 deals with a situation where tax has been paid on account of fraud, suppression, etc. So in our view, because this was an interpretative issue and has been unsettled very recently by the Supreme Court, till then the tribunal rulings were in favor. So even if the company pays the tax now, either fully or a notional value, it should not be affected by bar under section 74. So the last point, which in our view we should consider examining, is impact under direct tax laws, that if it is treated as import of service under GST law, will it be treated as import of service under direct tax laws, and withholding tax implications for fee for technical services will arise. Will it have a P implication or not? So we, being not an expert in that, will not be able to comment. But in our view, this issue will equally become relevant. In our clients, we have seen that they have been facing similar disputes, similar investigations with income tax authorities as well. So this is also an aspect you should examine. One thing we surely recommend is that if our case is not totally covered by Supreme Court ruling as is distinguishable, we should consider paying tax under protest. And it will also come handy for the direct tax position, where we can say that we are not accepting the liability per se, and we have paid tax under protest. So we still believe that these are employer-employee relationship. So such a stand will come very handy for direct tax purposes as well. So with this, we come to end of today's session, and thank you for joining in that large number and making it very, very interactive. Yeah, thank you. Goodbye.